Welcome to the AM report. So there are perceptions that this perjury case is likely to certainly give credence to the parliamentary process looking into the steps really to be taken to remove a head of a Chapter 9 institution. Do you see things the same way?
Good morning. Yes, thank you. Most certainly. The DA's application for her removal has already been filed with the Speaker, so this can't supplement it, but these allegations form part of our submissions, and certainly the decision by the Concourt has bolstered that application quite considerably. You can't, the Public Protector's Office is an office that is very important. It's a high office. It deserves to be occupied by somebody who's fit and proper, and we don't believe, nor have we ever believed, that Ms. Mkhwebane is a fit and proper person to hold that office.
And help us connect the dots if... Sorry, apologies for interrupting you there. Yeah. Help us connect the dots if you can. I mean, there have been several processes at different stages. What interest, if any, does the DA have in this perjury matter? Because, of course, we know that the parliamentary process was initiated by the organisation in Parliament.
Well, the parliamentary process was initiated after a series of unfavourable and scathing court judgments, after a series of unfavourable reports produced by the Public Protector that were challenged successfully in court, and each one just goes to demonstrate her inability to understand her mandate, her inability to understand the application of the Constitution to her mandate, and her inability to understand the space that her office occupies in a constitutional democracy. So for those reasons, we have brought this application for her removal. This perjury application, of course, bolsters that application quite considerably. Where you have a person in the Office of Public Protector, again, a high office, a lot of power, a huge amount of responsibility, who is charged now criminally with allegedly lying under oath 3 times regarding one report. That is an appalling state of affairs, and it simply can't continue. It demonstrates, in my view, quite clearly that Ms. Mkhwebane is not the person to hold the office of the Public Protector, and I've got no doubt that the panel that was appointed will certainly look very closely at this judgment, at the other judgments too, but at this judgment of the Concourt, and certainly these charges just maybe the last straw, the straw that broke the donkey's back.
Right, and that matter likely to play out in court in January next year. So really no telling the bearing it's likely to have. But it does allow us to have a conversation about the other salient issues that arise here. I'm interested to find out what reflections you think we should be having about the process that goes into the appointment of someone who essentially takes up the role of being the Public Protector of the country. And I'm asking this question because a lot of what the Public Protector herself has had to say in response to these court rulings and the subsequent reaction is the process and many other things against her are all politically motivated. And it certainly opens us up to trying to understand whether politics has too much of an influence in who takes up what's meant to be an independent institution.
Well, as you'll be aware, the Public Protector was the subject, the appointment of this Public Protector was the appointment of, was the subject matter of a very rigorous public appointment process. There were applications and nominations, there were public interviews. In my view, she had a really bad interview. There were people who had much better interviews and who were much more suited for the post. You'll recall that at the time, the DA did not support this appointment, unpopularly so, but we did not support this appointment at the time. And what happened is that the ANC used its majority to force it through. They did, however, have the support of the other opposition parties. As I recall, only the IFP abstained. and the DA voted against. Everybody else supported this appointment, despite the warnings that we gave, despite our pleading that they should reconsider. So clearly there's a flaw in the appointment process that allows a person of this caliber to be appointed, because at the time we raised the issue that we felt that she didn't have the requisite qualifications to hold the job, and we didn't feel that she had the requisite amount of experience to successfully perform this job. We had other objections too, but those were our principal objections, and it's proven to be correct. All the court judgments that are scathing, all the court judgments that go against the public protector have made some remark about her inability to understand her mandate, her inability to understand the space occupied by her office in a constitutional democracy. And so in that sense, we have been vindicated, but that doesn't help us. What we need a public protector who can do the job. And clearly the appointment process that was then applied did not succeed in that. And so we'll have to, once this committee has sat, and we'll have to have a look at their findings, we'll have to have a look at their recommendations, and then we'll have to perhaps revisit the entire process of the appointment of the public protector, because as you say, it needs to be a process that is that ends up appointing somebody who is independent, regardless of any political interest or affiliation.
Glynnis Breytenbach, let's leave it there. Thanks very much for your time.